A California conservatorship at its core is where you have to have the judge in the county where you live step in and appoint someone to make decisions for an individual. Now you may ask, why would a judge need to step in to appoint someone to make decisions for an individual? And this is when that individual no longer has the capacity or the ability to make decisions for themselves. Now, there are two types of conservatorships. One is a conservatorship of the person. This is where someone doesn't have an ability to make medical decisions for themselves, living decisions for themselves, or have the ability to provide care for themselves. Maybe they aren't cleaning themselves properly or able to get food, take medications. The other type of conservatorship is the conservatorship of the estate, and that is their assets. So this may be where they are unable to avoid undue influence. Somebody's taking advantage of them, or they're simply unable to understand their bills and pay them and adequately finance their life. So the court will step in at this point and appoint someone to make these types of decisions for that person. Many clients ask me, when is a conservatorship necessary? And there's two sort of situations that I find clients in. The first is they have estate planning documents in place. And when I say estate planning documents, I mean a trust document, a revocable trust, a durable power of attorney or any sort of power of attorney, and an advance healthcare directive or power of attorney for healthcare. All of these documents do different things. I like to think of them as three sort of columns that we have. So we have the conservatorship of the person. This can be replaced by an advance healthcare directive, a document which nominates someone to make decisions for you personally and with respect to healthcare. Conservatorship of the estate handles assets that are in someone's individual name. And those assets could also be, instead of a conservatorship, taken over by an agent under a durable power of attorney. And the third are trust assets. So a trust is literally its own legal entity. And when it holds assets, the only person that can exercise any control is the trustee. So theoretically, you could be in a situation where you have no conservatorship because you have a client who has a revocable trust that handles the trust assets. They have an agent under a durable power of attorney that handles the personal decisions and finances in their individual name. And they have an advance healthcare directive, right, which handles all the medical decisions. The biggest problems I see are, one, where people don't have estate planning documents at all. Your only option is a conservatorship, right, in order to take over those assets or make medical decisions. The second situation that I see is when those documents simply don't have broad enough powers, or maybe you're getting a lot of pushback from that individual who believes that they have capacity, and you need to sort of take away that power from them, either for their safety or for your concern of their safety.